Good morning. Thank you for joining. We will give just a moment to clear the waiting room. Morning. This is the voting hearing of the licensing board for the city of Boston. Today is Thursday, June 5th, 2025. Today's hearing is being recorded and will be posted to the City of Boston's website. While the public is encouraged to attend, there will be no additional testimony accepted this morning. Begin with the license premise inspection hearing, which occurred on Tuesday, June 3rd, 2025. As a reminder, Chairman Joyce was not present, cannot vote on the license premise inspections. Item number 1, Sullivan Saloon LLC, doing business as Sullivan's Tap, located at 168 Canal Street. Date of the incident, February 3rd, 2025. Assault and battery on a patron in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A, and refusal to cooperate with police in violation of Mass General Laws, Chapter 138, Section 64, and Board's Rule 1.10A and B.
I thought this one really didn't add up upon presentation. So, what do you think, Commissioner Saxon?
I would agree. I think that maybe there's correspondence about cooperation though. Even though like the facts itself, but we do need to make sure that
Yeah, I think that'd be good because I think there was some allegation it might have been a miscommunication. It was hard to tell exactly what was being said. This person apparently didn't work there, but that didn't seem to get through to the officer. So I think the correspondence would be appropriate. Yeah,
right, but no violation.
I agree.
No violation, correspondence, just with a reminder of the duty to cooperate with police. Okay. Item number 2, Gira and Tambora LLC, doing business as Gira and Tambora, located at 4014 Washington Street in Roslindale. Date of the incident, January 1st, 2025, assault and battery with a dangerous weapon, a knife, with a person cut, stabbed in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 15A.
So, I mean, based on the evidence that we were able to get out during the hearing, my initial thought is that it felt maybe the case fell just a little bit short, but I do have concerns about part of the reason why it fell short was due to the licensee. They submitted the video late, which made it difficult to really get into all the details during the hearing. The video that they submitted had kind of missing snippets. There was multiple missing snippets. I had seen one and kind of written it off as a minor thing, but throughout all 3 of the videos they submitted, there was multiple missing snippets, and there were at points where it could have been relevant. It seemed a little convenient, so I had my doubts there. And they didn't bring the right witnesses. They didn't bring the security guards in. So for all those reasons, I'd like it, correspondence and those aspects to be docketed, but it was right on the lines for me. Commissioner said, if you had anything to add, I'd like to hear your thoughts.
Was there any, did we, I forget, did we ask for the additional gaps? Did we follow up?
Yeah, we got an email saying that they didn't have any, that all they had was the video that they gave us.
Okay. Yeah, it definitely should be noted. I mean, I don't want to place too much in the gaps. I mean, since we don't have the facts, there's nothing that we can include, but I do think that it should be noted for the docket. And do they have a security plan? Did they submit? But there does seem to be a lot of instances in the videos that we did see where there could have been some, I guess, more clear about separating the parties, making sure that there was no way for these parties to interact.
Yeah, so, I mean, it was definitely on the line. Like, it's a they were in a difficult situation, but it was clearly volatile. It went on for a little while. In a perfect world, I would have loved to have heard that in the middle of that, they were calling the police already, that kind of thing, even before the knife came out, because this person wasn't giving up. It had gone on for a while. But it was a little just too close to the line. The one thing is we don't know where he got the knife.
Right.
The idea that he might have gotten the knife from outside in the midst of this was really, for me, the only thing that saved them. If we could have shown, more likely than not that the guy had the knife on him in and out of the place, he had been allowed to basically have it with him the whole time. I think it would have been a little bit different story as far as the premises' liability in this.
Well, I think the correspondence needs to be very thorough, talking about security, making sure that there's a de-escalation plan.
We requested one in the past, right? Attorney
So I
Green?
went back to the docket sheet. We have not, I think we were confusing this with another licensee, and then also
Okay.
looked at the historical file as well. There is no security plan on file for this licensee.
Okay, so I think we'll do,
Request it though? Is that because we didn't request it, or is it because they didn't
We
actually?
have not, it is not docketed anywhere that we've ever requested one.
Got it. Okay.
okay, so now we should request one, I think, that, as we have in many other places.
Yep.
Yep.
Um,
Call the
and-
police.
yeah, even before a knife comes out.
Yep.
If you have a volatile situation that you're not able to get under control in a couple of minutes, put the call in. It's the same thing. I think people are, they're resident to call the police before something actually happens, like punches thrown or knives coming out. But really, ideally, the call would already be in and they'd already be on their way. I mean, this could have been a lot worse,
It could have
and
been.
it would have been better if the police were already on their way.
Yeah, there was a kid inside there. So yeah, calling the police, de-escalation, security plan, also making sure that they submit the entire video, that there
Yeah.
are no gaps, and submitting it in a timely manner.
So no violation, correspondence with all of the above that you mentioned. We're also going to request a security plan that will include at minimum how they are dispatching their duty to call police and a de-escalation of their staff. And will be docketed as well that the licensee failed to timely provide video, that the video had notable gaps, and also that the licensee failed to present a witness with the firsthand knowledge of the incident.
Correct. Thank you.
Perfect.
Also, uniforms. I mean, I think it behooves any establishment to have very clear uniforms. I don't know whether.
Right, that can be something we request them to.
Identify who the security was.
Yeah, that can be something we ask them to put in their security plan as well. Great.
Yes, thank you.
Mhm. Item number 3, Boston and 4 LLC doing business as A.T. O'Keefe's located at 911 Boylston Street. Date of the incident, December 7th, 2024. Assault and battery, employee on patron in violation of Mass General Laws, Chapter 138, Section 64, and Chapter 265, Section 13A.
Okay, so I had a no violation in this one, but I did have a kind of a personal concern in the details, which is, I want security or, employees of premises to be more aware of the idea that if someone is being, difficult, it's not like free reign to like haul off on them. I know that they allege that they felt physically threatened, but I was somewhat unconvinced that definitely happened here. Some of the testimony leaned more towards the guy was just really annoying.
Yeah.
And therefore he had to go and he wasn't really listening. And so, it's very convenient to say, oh, I felt physically threatened.
Yeah.
So I just wasn't fully convinced. I mean, it was very clear that the employee said that he slapped him, full on slapped him. And then they brought, a customer, and the customer didn't seem to have the same story. So I thought those discrepancies were enough to say that, just the same kind of request about de-escalation, only using physical force when there's a true threat. And not really causing that physical threat by like going after this guy. So I'm not saying this is what happened, but I'm saying I'm not 100% convinced that it was a case of self-defense. And so that I want to make sure that, the threshold for self-defense should be high. So.
Yeah, I mean, I think verbal assaults, shouldn't equate to a physical touching. So I think in this case, they still need to watch the door. This was the one that happened at 2:30 or something.
Yeah, this was an afternoon midweek. I mean, not really a doorman situation, I wouldn't think.
Right, but so one, I think, no matter what time of the day it is, someone should at least keep an eye on the door, making sure that inebriated people are not just walking in willy-nilly. But then also, yes, that the force needs to be commensurate with the assault. So, if it's a verbal assault, then maybe it's training to have some sort of de-escalation that wouldn't involve an overexertion. So correspondence, I mean, I would say they're not, yeah, I wouldn't say that they're liable, but definitely some correspondence.
Yeah, I same thing. I mean, if they're listening, I think this was right on the line.
Yeah.
As far as them, if they're going to say it's self-defense, they kind of have to prove it,
Yeah.
And I was willing to say it was like a 50-50, but it was close. I have no violation.
Yeah, no violation, definitely a de-escalation plan.
We're seeking a de-escalation plan from them.
Yeah. What they talked about doing some retraining and stuff, so just we get that in writing.
That's correct. Great, no violation. We're requesting a de-escalation plan from them with correspondence.
Or proof of the training.
Proof of the training. Great.
Either one.
Item 4, same licensee, Boston Infor LLC, doing business as A.T. O'Keefe's at 911 Boylston Street. Date of this incident, March 25th, 2025. Patrons drinking on public way in violation of Mass General Laws, Chapter 138, Section 64, and Board's Rule 1.09D.
This was another tricky one. I take them at their word, and I believe that they were making these efforts throughout this time with these customers. But in spite of that, it still happened. So I was very much on the fence about this one. I think I need to push one way or the other.
I actually saw a violation, even though they did try, but things that slip through the cracks are still on the licensee. So
yeah, I think that's all the push I needed. I saw a violation as well. I mean, I was really close. I mean, I do think that they were making the efforts, but on the other hand, it's like, yeah, they saw it happening and they still kind of failed on it. So yeah.
But
so
they do have, they did submit a picture of the sign that says no drinks beyond this point.
Correct.
So, I don't know. Is there any history, Danny?
There's no history at this location.
When we do what we call progressive discipline, is it more of like correspondence first and on the docket?
It could be a warning. That's at the board's discretion, really.
I may back down. What do you think?
I think we can issue them a warning if nothing really comes of it, and if it doesn't happen again within a year, they'll be safe. So I think they can be warned about it.
That's fine.
Violation with a warning. Item 5, once again, Boston Infor LLC, doing business as A.T. O'Keefe's, located at 911 Boylston Street. Date of this incident, April 21st, 2025. Overcrowding, 159, mechanical count, capacity 93, in violation of Mass General Laws, Chapter 138, Section 64, and Board's Rule 1.03J and 1.06A and F.
I had a violation.
It was clear.
Yeah. But, and I didn't see any recent history, so that would be a warning as well, right?
Violation with a warning.
Yes.
Item 6, Town Alston LLC, doing business as Town, located at 194 Harvard Ave in Alston. Date of the incident, March 20th, 2025. Premise open after their posted 11 p.m. closing hour, in violation of Mass General Laws, Chapter 140, Section 9, and a blocked fire exit, in violation of Mass General Laws, Chapter 140, Section 9, and Board's Rule 1.06A.
Yeah, I mean, these are violations.
Yeah, I mean, the fact that they had the chairs up, it says that they knew it was supposed to be closed, and they were still operating as takeout.
So I think what happens, like on the main street, they have a big glass kind of frontage, but there's 2 doors.
Mm-hmm.
And I think they wanted just the customers to use only one of those doors. But clearly, it's the other door is marked as an exit with signage. probably, in the designs for egress and, exit and entry.
Yeah.
So, they need to keep both those doors open all the time and use them.
Absolutely, yeah. But there was two, so it was blocking the exit, but then also operating after hours, correct?
Yes.
Correct.
So I would find a violation for both, unless
Mhm.
there's I don't know, is it a global warning or we're finding two separate warnings?
They're not really related, so that I think we'll just on each individual one, they're gonna get a warning. So,
Yeah.
if they have another incident for one or the other, we can reference it.
Yes. Yeah, makes sense.
A violation with a warning on each.
Yeah.
Item number 7 is continued to the next available hearing date. So moving on to the transactional hearing, which occurred yesterday, June 3rd, 2025. Sorry, June 4th, 2025. Item number 1, Keen Cruda LLC, doing business as Brassica Kitchen and Cafe, located at 3710A Washington Street in Jamaica Plain, has petitioned to amend the description of the licensed premise to the premises identified as 3710 to 3712 Washington Street in Jamaica Plain. Space A and Space B are connected through a vestibule in the rear. Space A, the 3710 side, is approximately 1,307 square feet, with dining area with seating for 26, bar with seating for 5, kitchen, storage, and restrooms, and patio A, which is a seasonal April to November, approximately 440 square foot patio on private property with seating for 25. Space B, the 3712 side, is approximately 3,161 square feet with 3 dining areas with seating for 80, bar with seating for 15, kitchen, storage, and restrooms, and patio B, which is a seasonal April to November, approximately 227 square foot patio on private property, seating 18. The patios have a closing hour of 10 p.m. Sunday through Thursday and 11 p.m. Friday and Saturday. There are 2 means of ingress and 6 means of egress.
I would have vote to approve this one.
Me too.
Yes, I agree.
Item 2, Markiro Marketplace, Inc., doing business as Lambert's Marketplace, located at 10 Temple Place, has petitioned to change the category of the license to a retail package store all alcoholic beverages license.
Vote to approve with the recent requirement of keeping the space dedicated for alcohol on premise and available for inspection. And if they're going to change it, they have to come back to us.
I agree.
I agree.
And the licensee did agree not to sell nips/miniatures or singles. Is that a condition you'd like to see on the license as well?
Yes.
Is miniatures the same as nips? Is that?
Yeah. All right, so granted with conditions of no nips, no singles, and also no increase to the floor space dedicated for alcohol without approval by the board, and to keep the floor plan on site at all times. Item 3, Pasta Beach Rose Wharf LLC, doing business as Pasta Beach, located at 30 Rose Wharf, has petitioned to transfer the license to, actually, we have heard from the licensee since then with a revised application. The correct entity name of the transferee is 1928 Rose Wharf LLC, doing business as 1928 Rose Wharf. Underlying ownership is the same, and it's just the name of the entity has changed. It's at the same location with Kristen Jenkins, manager, and 1 a.m. closing hour. They have also petitioned to update the description of the premise to 5,303 square feet total, with 2,953 square feet on the ground floor, with main dining area and bar seating, kitchen and storage in rear, mezzanine level for additional equipment and storage, 2 entrances and exits off Atlantic Ave, additional entrance exit on northern side of premise, 2,350 square foot annual patio on private property with seating for 70, and a closing hour of 11 p.m. on the patio.
I'd vote to approve. I also request that they submit a plan memorializing the issues we discussed at the hearing regarding security.
I agree.
I agree.
Granted, with a request to submit a security plan specifically regarding the relationship between the licensee and the hotel security. Is that correct?
Yep. And patrons potentially leaving the outdoor premises to the Harbor Walk, which is an issue we've seen in other places that are similarly located.
Great. Item number 4, Harvard Convenience Inc., doing business as Harvard Convenience, located at 157 Brighton Ave in Alston, has petitioned to transfer the license to Patel Harvard Inc., doing business as Harvard Convenience at the same location. Tushar Kanabai Patel, manager. They amended the closing hour during the hearing to 11 p.m. They have since filed a revised application to memorialize that. And secondly, they have petitioned to pledge the license and inventory to Rockland Trust Company.
I'd vote to approve.
I do as well.
Agree.
Item 5, Water Dragon LLC, doing business as Blue Dragon, located at 324 A Street, has petitioned to transfer the license and the location to Maple and Ash Boston LLC, doing business as Maple and Ash, located at 131 Seaport Boulevard. Sean Gildea, manager. Closing time 2 a.m. indoors, 11 p.m. on the patio.
So I would normally vote to approve this. I just have questions about legal use. There were some allegations that some of the way that this is written would not be like within the legal agreements. And
Condo docs, I think, right?
yeah, so my question for the other commission is to what extent do we believe that's a private matter versus a legal matter? Like, and so, and are we constrained from, say, issuing a 11 p.m. patio closing, even though they're saying, you know, that's against our private documents, which could be legally enforced in a separate venue, but that seems to have not. I mean, I would prefer that this was all worked out before we ever got to a hearing, right?
Yeah.
But it seems to have not been. So, to what extent do we believe we're constrained by things like condo docs?
I had the exact same thoughts when I was listening to the testimony and then reviewing the application, and I don't believe it's our role as regulators to get into the private agreements between a condo association and an applicant like this. That being said, I don't think they can operate unless they are within the condo docs, but I think the recourse for the condominium association is someplace other than the licensing board.
Do we defer and allow them to work it out and then come back to us with a time that we can vote on?
I would just be afraid of holding up a transaction like this, a purchase and sale.
Yeah, to me, there could be theoretically there could be a point in the future where they do come to an agreement that, you know, where the patio can stay open to 11 p.m. And I wouldn't have a problem with that as long as everyone was in agreement. But it's, to me, it's not clear that it even, you know, it's merely an allegation from some of the people associated with the condo board that you know, is not allowable yet or at all. But but it wasn't proven to us either.
I agree. I mean, I was thinking that one way we could approach this would be to approve the transaction, issue the license in a way with conditions that they have to be operating within the requirements of their condo documents. Let the business transaction go through. In my opinion, in our eyes as regulators, as long as they're operating within their condo association documents, we don't really have a role to play to enforce that. That would be I would imagine those enforcement provisions are spelled out in the condo documents. As long as they're not violating any of those conditions, I have no problem approving it, but I don't want to get into the argument between the association and the applicant.
So are we approving 11 p.m. asterisks on the condition that it's approved by the condo association?
Oh, for the outdoor patio? Yes, as long as it's within the definitions of what's allowed in the condo documents.
Yeah, because normally what is here, I would normally approve it. You know, Seaport, you know, in a space that was always intended to be retail and probably a restaurant. They have a patio, you know, other places have 2 a.m. licenses, like all this stuff is not generally a problem. The only way it's a problem is if it's in violation of the condo docs, which is something we really don't have the capacity get all the way through. So I think that's the best we can do.
I agree.
So let me see if I can parrot this back to what the vote actually is here, which is the transfer is approved, manager of record is approved. It sounds like the 2 a.m. interior closing hour is approved, and the patio closing hour sounds like it is approved conditioned upon them receiving the necessary approvals or them demonstrating to us that they have the necessary approvals. Is that kind of where we are on this?
I mean, I think we can license this as based upon what's before us today. If the condo association is alleging they're not allowed to do that, I believe there's recourse. I would imagine there's recourse within the condo documents. I don't believe we play a role in that.
Yeah, Attorney Green, I think the best we can do is state a preference, really. Like, we're never gonna adjudicate what the condo docs say
Correct.
and what is legal and what is not, legal as a matter of contract. I think what we can say is that we would prefer if the licensee didn't knowingly flout the rules as they understand them, and then basically make the condo association stop them from doing something they know that they're not supposed to be doing.
So we approve the application, but we're saying we're not making any legal implication as to the validity of the condo association.
Yeah.
Documents. It's like it's not we're not making a legal adjudication of that disagreement.
Yeah, we're certainly not saying, because there have been allegations that this is not okay. We're not saying that under the docs this is okay. We're not trying to put our thumb on that scale. Right.
Correct. So is there a condition here that the board is actually?
I don't think we can condition it. Yeah.
Great.
Okay.
So then it is just approved across the board.
It's just approved.
Okay.
Yeah.
Yeah.
All right. Thank you. No, this is great. And then items 6 through 9 are all new license applications that did meet the May 23rd deadline. There are still more in the queue. Would the board like to defer deliberations on these new license applications?
Yes.
Okay. In that case, moving on to non-hearing transactions, the following are applying for a new common victual license at a previously licensed location. Item 1, Pica Pollo LLC, doing business as Pica Pollo, located at 3160 Washington Street in Jamaica Plain. Manager Jean Carlos Lizardo, hours of operation 7 a.m. to 11 p.m.
Oh, I vote to, yeah.
I agree.
I agree.
And item 2, Boston Sweet Cravings LLC, doing business as Boston Sweet Cravings, located at 1 Faneuil Hall Square. Manager Farid Nouri, hours of operation 10 a.m. to 7 p.m.
I vote to approve.
I do too.
I agree.
Following is applied to make changes to their pre-existing approved outdoor dining patio, as these no longer require ABCC approval. Morton's of Chicago, Boston Seaport LLC, located at 2 Seaport Lane, has applied to expand their patio as follows: to 1 room and kitchen on the first floor with entrances and exits to lobby in both Seaport Boulevard and Seaport Lane, basement for storage, an annual Four Seasons room that is approximately 929 square feet with sliding windows and seats for 62 patrons, and an additional outdoor seasonal patio on private property for 54 patrons between 11 a.m. and 11 p.m.
Vote to approve.
I do as well.
I agree.
And the following have applied for one-day amendments to their existing licenses. Item 1, Notch Brighton Taproom LLC, located at 1420 to 1440 Soldiers Field Road in Brighton, has applied to extend their license onto the contiguous space of the Speedway Annex for a wedding rehearsal dinner on June 6th from 6 to 9 p.m.
I vote to approve.
I do as well.
Agree.
Item 2, Powder Dry Inc., doing business as the Leader Bank Pavilion, located at 290 Northern Ave, has applied for early alcohol service on a Sunday beginning at 10 a.m. This is on Sunday, June 15th, to accommodate the McCourt 5K road race.
Vote to approve.
I do too.
And item number 3, Inishowen Inc., doing business as the Dubliner, located at 2 Center Plaza, has applied to extend onto their contiguous patio space for an outdoor party on June 14th, July 19th, and August 31st from 12 to 8 p.m.
I vote to approve.
I do too.
Agree.
The board has before them a list of applications for special one-day alcoholic beverages licenses, which have been administratively reviewed by staff for approval by the board. And those are all of the items before the board this morning. That will adjourn this hearing. So thank you all and have a great rest of your day and weekend.
Thank you.
Thank you.
Thank you.